by Freedmen in Antebellum, Virginia, as well as the complexities that lie within that. So in this study, when I'm referring to freedmen, I'm talking about those free from slavery in the antebellum United States, specifically African Americans. Now this could be achieved in a number of ways, primarily through manumission. This is where a master would voluntarily free their slave through legal means to achieve free status. They could also be freed through familial descent, so if they descended from free parents, they were granted that free status at birth. Virginia is a very important locality to study when discussing freedmen because of a number of reasons. Virginia had one of the highest freedmen populations during the antebellum period, except for Maryland. That was its one rival there. And then also it was the center of key topics during the ongoing slavery conversation in the antebellum South. So events like Nat Turner's Revolt and the slavery debates in the Virginia legislature the years following that were not only impactful in the Commonwealth of Virginia, but throughout the entire United States. So early on, not soon after America gained its independence, we see the Virginia State Legislature placing limits on freedmen. First one would be in 1793. This was a law requiring freedmen to register themselves with their county of residence. This began the practice of freedom papers, in which freedmen needed to carry their freedom papers with them in order to prove their free status if ever questioned by authorities. Another law in 1801 prohibited employment outside of their county of residence. So although the punishment for the violation of this law fell on the employer, it still limited their economic opportunities. It limited it to their county of residence. One of the most impactful laws during this early antebellum period was passed in 1806. This law required newly freed men to leave the state of Virginia within 1 year of manumission. The objective of this law was to limit the freedmen population, keep it at a steady level, keep it at a low level. And then later on, as the antebellum period progresses, in 1831, we see laws passed prohibiting gatherings of people of color for any educational purposes. Religious purposes also fell under this category. So there's a common theme throughout all of these laws. It's to limit the economic, educational, and religious opportunities of freedmen. You know, they're limiting their residence, their home, their jobs. So this was to control the freedmen population, keep it low, keep them in one place, keep them under control. Now, there was a huge shift in attitudes in Virginia in 1831. This occurred primarily because of Nat Turner's Revolt. Now, this occurred in 1831 in Southampton County. Nat Turner led a group of over 75 freedmen and slaves to murder 50 members of white slave-owning families. Now, this massacre triggered immense fear in Southern whites of the possibility of a slave revolt. It had happened, these fears have been actualized, and this led to slavery debates the next year in the Virginia legislature. Is Virginia able to economically sustain slavery? Is it morally reprehensible? This is something that was being discussed in these debates. But how were freedmen affected by this? Well, because of the slave revolt and the uprising, many saw freedmen as an inspiration to slaves. They served as, oh, if freedmen are here, they're people of color with free status. They serve as an inspiration for slaves to revolt and to uprise. And that was, of course, not what they wanted from their experience with Nat Turner's rebellion. So the change in attitudes that occurred in the latter part of the antebellum period had varying impacts depending on the locality. So in urban regions, freedmen were impacted differently than in rural regions. In Thomas Bogger's study on Norfolk, Virginia, he notes that it was a really miserable existence for freedmen during this time. It's an urban center, so it's attracting not only freedmen for economic opportunity, but also European immigrants. So they were, fighting among that socioeconomic status. There was lots of intense competition for job opportunities, housing, things like that, and that led to animosity among those different groups. And from that, further reports, further court cases, reporting freedmen, for more strict enforcement of these laws. Freedom papers were more readily applied and things like that. Lynchburg was a similar case. It was important for freedmen to weigh out whether economic opportunity outweighed the opposition they faced socially and legally. However, in rural areas, it was slightly different. As Dr. Melvin Ely notes in his book, Israel on the Appomattox, there was sort of a live and let live atmosphere in these rural regions. So although this doesn't count any sort of racial utopia whatsoever, it does note that as long as freedmen didn't uprise any political gatherings or form any sort of political groups and followed the laws and contributed to society, these laws weren't readily enforced on them. Similar cases echoed in a study on Cumberland County. Ellen Katz conducted a similar study. She noted that the state laws that were passed by the Virginia legislature did not at all reflect what was happening on a day-to-day basis in these regions. So Campbell County is an important locality to study because every region is unique. As we saw with Norfolk, Lynchburg, and Prince Edward County, each has its own unique story, so it's important to look at these counties on an individual level, counties or cities, on an individual level, individual basis. There is no known study on Campbell County. What we do know about freedmen in Campbell County, we know through courthouse documents. Because of low literacy rates among African Americans during this time, courthouse documents provide perhaps the most objective view of the legal obstacles faced by these freedmen. And it also shows a variety of ways in which freedmen navigated through these legal obstacles. So Andrew Holt is perhaps the most well-documented of all freedmen in Campbell County. He was born sometime around 1783, the late 18th century, in Kentucky into slavery. In 1807, he was manumitted by his master, Thomas Holt. And Kentucky had a similar law that Virginia did during this time. He had to vacate the state within 1 year of manumission. It's unclear what occurred between 1807 and 1822, but in 1822 we start seeing his name in Campbell County courthouse documents. He's purchasing properties, and between 22 and 35, he purchased over 41 acres of land within the town of New London and also surrounding areas. Holt also worked as a wheelwright and a baker to earn that income, and he was a community leader in the African American community of New London. However, in 1842, we see the first instance of this intense opposition that freedmen faced. He was brought to Campbell County Courthouse for an unlawful assemblage of people of color in his home. Now, looking at what he would do in the future, this was most likely a religious gathering, but nonetheless, this court case was filed. He appeared before the Campbell County Courthouse, and the case was eventually dismissed. However, this shows that even within his own community, as a leader, as a future founder of the African Methodist Episcopal Church in New London, this huge figure donating this church to the African American community, he's still facing legal opposition. He's still facing trials from his own community. Similar case is happening with his son, Dennis Holt. Now, Andrew Holt purchased his son, Dennis, so he was enslaved, although his father owned him. This was something that freedmen often did with relatives that were enslaved. So they were enslaved on paper, but they still were within their own family. Now, when Andrew Holt passed away between 1854 and 57, in his will, he freed both of his sons, Dennis and Burwell. Now, Dennis, however, was married to an enslaved woman in the New London community named Nancy. So because of that 1806 Virginia law, he was forced to leave the Commonwealth of Virginia, leave his wife and family, or give up his freedom. So he chose to give up his freedom, and he petitioned to be re-enslaved under the master of his choice. He chose David Hoffman, who was the master of his wife, Nancy, and it says here that he greatly prefers to enslave himself to the said David Hoffman to going out of state. And this shows the limited opportunities that they had. They're freedmen, but are they really free? No. they have all these obstacles that they're facing that they have to jump through. And it shows the dedication that he had to his family, that he was willing to give up this freedom. Billy Williamson chose to go another path with the same situation. He was manumitted in 1850 upon the death of his master, D. Williamson. And he chose to petition the state of Virginia to remain. Now, in these petitions, it required a lot of character references. So within these character references, they're noting his stable family life. He had been married since 1830. He had 8 children. He was an important community member. He was a farmer, and he contributed well to his community agriculturally. And this was supported by over 47 of his community members, as you can see here. So even this highlights the complexity very nicely. It shows that even though within this petition, he's filing to remain in the state of his birth, but he is still supported by many of his community members. So there is some light within the darkness. Ned Adams took a similar route. In 1833, he was manumitted upon the death of his master. The next year, he petitioned the state of Virginia, and in this case, there are over 150 of his community members that supported this petition. So you can see the support that he had, the love that his community had for him, even amongst this intense legal opposition. Now, another obstacle faced by freedmen during this time was the rescinding of their freedom. Millie, her last name is not noted in this document, was born into freedom. She descended from free mother, but somewhere along the way that was revoked. This could happen throughout slave purchasing and things like this, but she filed a lawsuit against Virginia to grant the freedom of herself and her children back. So the claims that she had for this freedom was the free status of her maternal line and also the Native American descent from her maternal line. This was a precedent that dated back to the colonial era, specifically in the French colonies. And if this was, a precedent that they did not enslave Native Americans, so if you claimed white status or Native American heritage, this would help boost your argument for free status. So as a whole, Campbell County, what was the legal experience that freedmen had in this area? It's complex, as I noted at the beginning, but you can see that there's immense opposition coming from the state level. The day-to-day activities, how well they reflect that, it depends. As we can see, there's several court cases. There's freedom suits being filed. There's petitions to remain in Virginia. There's even from the county level, people in Andrew Holt's community reporting him to this county officials. So there's obviously some immense opposition, but there is within that immense community support. So it's a very complex picture, and it's important to look at these localities individually. If I were to label Campbell County and what it's most similar to, probably reflects more of Prince Edward County and Cumberland County, those rural regions where the law isn't as well enforced on a day-to-day basis. But of course, even in those areas, the law is still the law. There's always that threat looming over their heads. So in those court cases, you can see that there was still threats in their lives, that legal opposition that they faced. But the further studies would be needed to indicate whether or not this was more of a rural experience or an urban experience, but it would lean more towards rural in my opinion. Thank you very much for listening.